All right, guys. Good morning. Welcome. My name is Liz Hansen. Sorry, I got a little frog in my throat. My name is Liz Hansen. If we haven't met, I am a photographer and I run the Chicago Boudoir photography studio. My business is Boudoir, but my bigger mission is to help women feel confident and empowered in all areas of their lives. And I love to bring guests to this group who can help you in feeling confident and making decisions and being independent, all the things that we want to be. And today I'm so excited to have Lisa with us. Lisa is a divorce attorney. Lisa, welcome and introduce yourself for us.
Good morning, everyone. Thank you, Liz, for having me. My name is Lisa Demonte Cervone. I am a divorce lawyer. I practice exclusively in family law. I've been practicing just about exclusively in family law for 12 years. And I am a Chicago native, grew up in the suburbs and currently live in Chicago. And I'm very happy to be here to talk with all of you. So today, what I'm going to be talking about is what every woman needs to know from a divorce lawyer who has seen it all. And so I understand that some people have submitted questions. We might not get to all of them, but I'm, like Liz said, I'm going to give you all my contact information. And for today, for purposes of today, I'm giving general advice. I am a lawyer. I'm not your lawyer yet. If you need me, I'm here for you. And if we don't get to your questions or you want further follow-up, normally I do charge for consultations, but I am going to do, as a courtesy to you and as a thank you to Liz for having me, I'm going to do a free 30-minute consult with each of you to the extent that you want it. So I just want to give you 3 or 4 big high-level tips about challenges that women uniquely face, and not just in divorce, but in if you're in an unmarried, relationship and you have children together, or just an unmarried partnership. So number 1, my first most important point is marriage is a partnership, and you are entitled to complete transparency and complete access to all of the financial information, which is assets and income earned by your spouse. So just because maybe you held separate accounts during the marriage and you never saw your husband's income, or don't have no clue what the assets are, just because they're titled in his name, the general rule is that they are all marital assets, and you are entitled to see every document that exists under the sun. You may not want to, you may say you already know, but for those of you that don't know, you are entitled to transparency. My second big point that I want to talk about is an issue that, generally speaking, the majority only affects women, and that's domestic violence. I have worked with countless women and men in domestic violence, but 99% of the cases are women as the victims. And I want to just leave you with one point. Yes, of course, physical violence is domestic violence, but also verbal and emotional abuse and threats also can qualify as domestic violence, and maybe that makes you a candidate for an order of protection. And if you have children, if your spouse or significant other is abusing you, whether physically, verbally, emotionally, threats, but they've never touched the children and they're a great father, abuse directed at the mother in the presence of the child is considered abuse of the child. So you could get an order of protection protecting your children as well. Third point, hot topic these days is divorcing or co-parenting with a narcissist. There's a scientific definition for what is a narcissist. I'm not qualified to tell you what that is. Many of you already know or have, read about it online. Co-parenting with a narcissist is a skill. Do not try to do it alone. Get a therapist or a parenting coach. And not to mention, everyone going through a divorce should avail themselves of some sort of therapy. Just don't do it alone if your spouse has some sort of personality disorder, whether they're a narcissist or borderline, depressed, anxiety, all of that. And those are my top points for you. So I think we can get to the questions now.
Lisa, thank you for sharing that. I think so many women feel stuck or don't take action because they don't know what is available to them in terms of their rights. Like when you were saying that someone who abuses a mother in front of the children is considered abuse of the child, like I didn't even know that. And but when I think about it, like of course, a child witnessing their mother being abused, of course that's detrimental to the child. So I think one of the most important things women can do is to empower themselves with information and knowledge about their rights and about what's available to them. So thank you so much for sharing all of that.
You're welcome.
Tell us a little bit, Lisa, just tell us a little bit about yourself and how you got into law and family law. I'd love to hear your story a little bit.
Yeah, so I have an undergraduate degree in business, and I grew up where my family owns a family business, and I never wanted to own a business per se. When I was getting my business degree, I took business law and really liked it, and then decided I want to go to law school. But my focus was actually going to be when I thought I could save the world, to help all the abused and neglected children and work for the government. And my mother actually convinced me not to do that because she knows me well, and I kind of have a bleeding heart, and I think it would just be too much on me. And God bless the people who do that work, who work with abused and neglected children day in and day out, because somebody needs to do that job. But on top of that, there were also no jobs when I got out of law school in the government arena. So I ended up going into private practice in divorce, and I still get to indirectly help children, but I love what I do, and I get to help mothers and fathers and people, which is also something that was my goal. So I love what I do, and I love my path, and this is how I got into it.
Yeah, I know. I feel like sometimes lawyers get sort of a bad rap in popular media and stuff, but like we need lawyers and lawyers can help you. So if if you're listening to this and you're in a situation where you feel like you could use a lawyer help, Lisa has so generously offered a free consult. So take advantage of that. We'll be leaving her contact information. Okay, so we got a bunch of questions. We're going to try and get through as many as we can. Again, this is not actual legal advice, but generalized advice from a lawyer, but Lisa is not your lawyer. We're going to try to hopefully by hearing some of these questions, it will help you with your situation, even if it's not your question. Okay, so I'll just go through some of these. If you have questions or comments about this, leave it in the comment section. We'd love to hear from you and what your thoughts are about this. All right, so our first question is this. I didn't have a lawyer when I got my divorce. I had a lot of guilt because I got the divorce because I came out as lesbian. I felt bad for my ex-husband. Anyhow, the divorce has been finalized now for 9 months already, and I'm realizing that I was a fool to not get any child support or anything out of the divorce other than my own car. I'm not happy with the parenting agreement. He named himself as the custodial parent, and we have 50-50 parenting time. He's trying to do things without my consent, like move my child to a private school. He leaves me out of all medical decisions, even though on paper we agree to make those decisions together. How would I be able to take him back to renegotiate on any of this?
Okay, so very good question. Once a divorce is final, the property division itself, so the car, the assets, etc., that's final. Anything relating to the children and support is always modifiable. So parenting schedule, always modifiable. You have to show the court that a substantial change in circumstances has occurred that warrants a modification for the best interest of the children. So if you don't like the 50-50 parenting time, you can do a petition to modify the schedule based on the best interest of the children. In addition, sounds like there's some enforcement issues. So he wants to put your child in a private school without your consent, and he leaves you out of medical decisions. You need to take him back to a process, whether it's court or another process, to enforce the fact that he needs to keep you involved in the decisions. And whether that means if his behavior is so egregious, then maybe that means you need to be the sole decision maker, because part of being a fit parent to make decisions is co-parenting and facilitating the relationship with the other partner, right? So parenting time, always modifiable based on the best interest of the child. Child support, always modifiable as well. Even if you were to sign an agreement that says, we agree that child support is $0 or $500 and never can be changed, that is not enforceable. It's the right of your child, and the judge or whoever is the mediator is going to say, no, this is what would happen because it's the right of the child, and this is what child support needs to be. So you have to, so in order to modify support, you need to show, again, a substantial change in circumstances. So maybe there hasn't been a change in the 9 months. Maybe there has. That's a conversation that we can have separately, but changes in circumstances are, the needs of the child. Somebody got a raise or changed jobs. Somebody lost a job. Children's expenses, which can be medical, extracurricular, school expenses, all those things. If child support was reserved, you don't have to show a change in circumstances. If it was reserved and just not dealt with, you can file a motion at any time to set support. So a lot of detail here. We should obviously have a separate conversation. I could run the numbers for you to see what would child support be if you pursued it before you take any action.
I think also one of the things I'm hearing in this comment is just, maybe you don't love what you had in the past, but there's always a way forward to make some changes and to not get mired down in like the past.
Agreed.
Okay, next question. I was sexually assaulted on a work trip by my then boss 10 years ago. I didn't want to face it at the time. Is it too late to press any charges now?
Yes. So this is obviously a really serious question. This is not a family law question. What I can tell you is I can give you, you need to speak with an employment lawyer. I have some referrals. I can give you a name and a, contact information. There might be a statute of limitations, which might bar you from bringing the action after a certain period of time, but don't let that stop you from inquiring, because I don't know, I don't practice in this area, and there's always some nuances. So talk to an employment lawyer. I am happy to give you a name and a number for somebody who can do that.
Perfect. Thank you so much. Okay. The next question is about GALs versus trained social workers. And GAL, I understand, is a guardian ad litem. And it says, how can we make the family law? Oh, nope, that's the next one. So just the question of what's the difference between a GAL and a trained social worker?
Yes. Okay. So a GAL is a lawyer who is appointed to represent the best interests of your child. So your lawyer is your advocate. Your husband's lawyer is his advocate. The GAL is your child's advocate. They conduct an investigation and report back to the court as to what they believe is to be best for the child. And the investigation includes interviewing parents, maybe meeting the child if they're old enough, observing the play, or observing, parent-child interactions, maybe talking to teachers, doctors, etc. A social worker is a GAL is a lawyer, because they're an advocate for the child. A social worker is a mental health professional, and I agree. Like, I love that you're raising this question, because lawyers aren't trained in mental health fields, and there should be some, and there's some training for GALs in the mental health aspects. But the reason why a GAL is a lawyer is because their role is to advocate for the best interest of the child. If your child needs a mental health professional, then they need that as well. They need some sort of therapist or social worker, and GALs often communicate with social workers. But the role of the GAL is to advocate for the child and report back to the court.
Now, if you as a woman, if you have an attorney, can that attorney also represent your children, or do you have to have a separate GAL for the children?
An attorney can only have one client, and they can't, you could potentially be at odds. Most mothers, they're looking out for their best interests of their child, but in sometimes, the child's needs are different from what the parent thinks is best. And that's why if I were your lawyer, I cannot represent your children.
Interesting. I didn't know that. Okay, we're all learning a lot today. Thank you, Lisa. Okay, next question. After a divorce is finalized, what are the best steps to take when the parental requirements are not being met? This could include financial, visitation, logistics, etc. I feel like every divorced woman I know, including me, is not getting the things that we were agreed to in the that we entered into in the agreements, but no one knows how to fix it or even feels like they can.
So there are a couple remedies for somebody not following a judgment. Number one is typically when they're not paying child support, you go in and seek to hold them in contempt for violating a support order. And the reason why you want to seek the contempt is because that's your avenue to get him to pay your legal fees if he truly is, blatantly disregarding a court order for no reason. On the parenting, it's a little trickier. So let's say, he's not following the agreement. You can seek contempt, but there has to be a purge for the contempt. So in child support, the purge is pay what you owe and pay the fees. Parenting, let's say he's just not exercising parenting time. The purge, I guess, would be he's got to pay your childcare expenses, maybe. Let's say there's a provision that says, nobody's supposed to introduce a new significant other within a year of the divorce, for example, and he did it already. It's hard to undo that. There are certain things that are difficult to police, but you do need to talk to a lawyer about your specific situation because maybe it's grounds for modifying. So there's one avenue is the contempt to cure the violation and then some, meaning the fees. Or maybe you need a modification. Maybe you need to modify the parenting agreement. Maybe this person is making bad decisions and they don't deserve the rights, all of the extent of the rights they were granted, whether that be decision-making, the amount of time spent. Maybe they're showing their bad judgment. So maybe it's a way to modify your parenting agreement. But there are absolutely remedies. The frustration is that the time and the expense it takes. And I know a lot of people had questions about expense. Court isn't a perfect system. And what I always say is your family dispute doesn't belong in court. So I always recommend mediation, collaborative, or some other out-of-court process. The courtroom was not designed for family disputes. Sometimes you have to go to court in cases of domestic violence, emergencies, or maybe you're just dealing with such a difficult person that you can't get them to cooperate in a amicable process. But there are remedies, so don't give up. You need to at least hear out what your options are. And if you decide you're going to wait, fine, but at least just talk to me or another lawyer to hear what your options are.
Another thing I've heard is to keep really good records. So if there is violation, like start writing it down and keep notes, right?
That is 100% right. You should, especially with parenting, keep records. If you can have a calendar that says such and such date, dad was a no-show, or dad was late, or dad, forgot to give baby their prescription. Very important to keep records because when you go to court, maybe you're going to wait a year and gather a huge list, but you want to have the detail, and that's really important.
Okay, fantastic. All right, next question. You ready? What is this is a similar related question. What is the cost benefit analysis of modifying parenting time to implement an ROFR? And I don't know what an ROFR is.
Yes. So ROFR is right of first refusal. And what that means is if somebody's unavailable during their time, they have to offer that time to the other parent rather than letting grandma or some unknown babysitter watch the kids. So right of first refusal is in most parenting agreements. Generally with younger kids, babies, toddlers, it's a shorter duration because if you're gone for 4 hours, then that baby should be with mom or dad, right? If the kids are older, most judges will only say it's an overnight. So if you're gone for 4 hours, you can use whoever you want. But if you're gone for an overnight, then you must give it to the other parent. So it kind of gets longer as the kids get older. So right of first refusal, it's a big contentious point for some families. So look, I love that you're thinking about cost benefit. That's the way I look at all my cases. And I always advise my clients, here are your options. I can't always estimate exactly the cost, but it's important to look at the cost if you're trying to pursue something. I can't answer that until I hear your specific situation, what your conversations have been with the father of the children about it. Are they really difficult? Are they amenable to discussion? Then I can give you the cost benefit and, knowing more about your kids and their unique circumstances.
She follows up, my ex regularly works overnights on his parenting days. I don't really care about child support, but I do care about who is taking care of my children.
Overnights, absolutely, you should have them. So maybe your parenting agreement wasn't thorough and didn't address it, but that is, I would say, very, very good reason to pursue it, because most judges will give you the overnight.
That's good to know. All right, next question. I'm not divorced, but I've been separated and I'm not divorced, but I'm separated and going through a custody battle. What is the likelihood of forcing the other parent to have a psychological evaluation done? There's a long documented history of erratic behavior and lies about his entire life. Also, would the courts accept written statements of other people who can testify to the erratic behavior and lies?
Great question. So, there are a couple different mental health evaluations. Generally speaking, when you're in a custody battle, you do what we call a 604 evaluation. And 604 is just the number of the statute. But basically what it is a professional who's like a PhD psychologist will go in and do a full-blown evaluation, meet everybody, meet parents, meet grandparents, meet the children, do psychological testing of the parents, maybe, and of the children too. Talk to teachers, social workers. This is way more involved than the GAF thing that we talked about. This is a PhD who does psychological testing. These are expensive, but they're needed and they're worth it in some cases. So all you need to do is basically get to the point where you don't agree on a custody schedule and full parenting agreement. Then you petition. You're probably going to have to get a GAL involved as a first step, and then the GAL recognizes these people aren't going to agree, or there's really big issues here that a GAL who's a lawyer is not qualified to address. Then you get the 604, who's this very educated mental health professional who does these evaluations all the time. They do a full evaluation. It takes a couple months. They write a lengthy report. That report goes to the judge. If one part, and they make a recommendation for a full parenting agreement, decision-making, custody, right of first refusal, all that. Then if one parent doesn't like it, they can counter that report with another expert. Usually the first report is kind of the gold standard. Another evaluation that can be done is if somebody's mental health is in question. It is called a 215, and the 215 is strictly to evaluate one party's mental health, whereas the 604 is looking at the overall best interest of the children and looking at the whole picture and giving a recommendation into the parenting agreement or the parenting judgment, even if it's not an agreement. The 215 is just, for example, let's say one person made a threat of suicide. Their mental health is now in question. We're going to interview this person, do psychological testing. We'll have an interview with the other party, a brief one, but really this is just about one person, and that's 215. The 215 is less common, but they're done. Those are the main ones. There's also, you can do a home study evaluation if somebody's concerned about the home environment. Like, that's also really less common, but really it's the 604 and the 215.
We're getting a comment that a 604 can be super expensive and cost $20,000. Is that true?
It could. Yep. That's another consideration. That's why the GAL is the first step. And it's not a perfect system. Your best case scenario is talking to your spouse and reaching a deal on your own with a lawyer guiding you. Next step is, we can't do this. We either need to go to mediation, and I'll talk about process too, because that's important. If that failed, then the next step is the GAL, which is the lawyer. If the GAL can't get it done, then the 604. And yes, it can cost up to 20 grand, which is why you have to really, and it's terrible for some families where you're dealing with someone with a mental health problem on the other side and they can't be reasonable. it's an issue. And again, it's not a perfect system, but yeah, it can cost that much.
We have a comment that said, yes, I paid 20K for a 604, but it was the best money I ever spent in order to protect my kids. So I guess the short answer is that it depends on your situation. If it's really extreme, maybe this is what you have to do. But
Yep.
maybe if it's less extreme, you could come to an agreement with your lawyers instead.
Correct.
Okay, thank you so much for that. Okay, next question. All right, we have been separated since 2016. He lost the house to foreclosure. Our kids are 24 and 18. We really have nothing left to split. He has a pension with the union he's in. I don't have any money to start the divorce process. What would be the least expensive way to start the process, and how much approximately do you think it would cost to get divorced?
Yeah. So private lawyers charge a retainer up front. If you truly cannot come up with a couple grand for a retainer, then you need to go to legal aid. There are many legal aid organizations. You can only qualify for legal aid help if you fit the income criteria. So if you have no income and no assets, you're probably going to qualify. Where depending on what county you live in, you can go to the county courthouse, and ask them for a list of legal aid attorneys. Sometimes they work on a sliding scale, where they charge you a really low rate. If you can come up with a retainer, the best way to do this cost effectively, and this is where I'm going to talk about process, is what I call the kitchen table agreement. And the kitchen table agreement is your absolute best case scenario. You sit down with your spouse at the kitchen table or at a coffee shop, and you say, how are we going to get divorced? We don't have any assets. You just have your pension. Let's split the pension 50-50. You're not going to be able to effectuate that on your own. You do need a lawyer to do the pension documents. I can't remember if you said you had kids or not. So assuming your kids were older. Yeah. Okay.
24 and 18.
Okay. So no child support, no parenting agreement, because your youngest is 18. There is no parenting agreement required. You just need a bullet point list of this is what we agree to. If you are a candidate for spousal support, then you do need that in the agreement. If he's working and you've been married a while, you should pursue that. Then you present your bullet point list to a lawyer. Somebody hires a lawyer, and the lawyer just drafts it up, and you both sign, and you're done. There is going to be some expense, but that's your best case scenario. Now, I would suggest that you be the one to hire the lawyer. The lawyer cannot represent both sides. So if your lawyer drafts up the agreement and send it to your husband, they have to say, husband, I don't represent you. I'm not giving you legal advice. If you're going to represent yourself, go ahead and sign. Or if you're going to hire a lawyer, have your lawyer call me. If you're on the receiving end of that and you get a letter and this is the agreement, I would never have you just sign that blindly. You need to at least talk to a lawyer, have them read it. There's a lot of devil in the details that a person who's not a lawyer isn't going to understand. Even if they could be a doctor or an astronaut, they still need legal advice, and it may be just a simple 2-hour conversation to say, hey, here's your rights, here's your obligations. This looks good, or I would tweak this or that. Don't do it without talking to a lawyer. And hopefully it is consistent with what you guys agree to, and it is simple, and your lawyer's going to say, tweak 1 or 2 things and then sign, and then you're done. That's your best case scenario. That's the kitchen table agreement. And again, if you cannot hire a lawyer to begin with, just go to legal aid. There's a few other processes which I touched on. These are called alternative dispute resolution, and they're completely out of court. One is mediation. There's a neutral third party who serves as your mediator, whose sole task is to guide you toward an agreement. It is not the mediator can't make a binding decision, but they guide you toward an agreement with the help of your lawyers. I do that all the time. That's the most popular alternative dispute resolution. Second one is collaborative. Collaborative is a somewhat novel, it was on the rise and a little bit trendy in the past decade. It's losing a little bit of momentum, but we still do it. I really love the idea. Doesn't work for every family, but the idea of collaborative in a nutshell is not, I want half the assets, I want half the income. we don't talk about positions. We talk about, I want to retire by age 65. I want to pay for my kids' college, and I want to, or something like, I want to rehabilitate my career and get back on my feet because I've been a homemaker. And then you fashion a settlement that fits those goals. So you're looking at goals rather than positional, and no reason behind the positions other than to spite the other person. That's collaborative. Third is arbitration. Same idea as mediation, but the arbitrator makes a binding decision. And the fourth is med-arb, which is you start as mediation. If you can't get it done, it converts to arbitration and they make a binding decision. All of these are better than court. If these fail, then you go to court. Court should be your last resort. Again, when you're in court and you're in a custody trial or any trial, you can't speak freely. You can't say what's on your mind. You have to wait for your lawyer to ask a question, deal with opposing lawyer objection to almost everything you say. You have to look at exhibits, authenticate exhibits, go by the rules of evidence, wait for the judge to tell you when you can and can't answer. Not for family disputes. You don't want that. So you should use one of the out-of-court processes.
There's a lot to know here, Lisa. And I love how you say that even if you're a doctor or an astronaut, you still need a lawyer. Okay, let's do the next question here. I know some of you watching have been through this and know how grueling and how much, like you said, the devil is in the details. So let's just go on to another question, even though I know we can't cover every single facet of every question. Okay, the next question is about college, and it says this: why won't judges put college into agreements? I've heard, why do they wait for it to be, quote, ripe for review? Hear me out. I understand if you are dealing with 5-year-olds today that in 12 years things can change, but things can also stay the same. In both cases, you'd still be back to court to modify the agreement. What about this next scenario? At the time of finalization, the child is 17 and only 9 months away from graduation. The judge still won't put college language into the decree. Why?
Yeah, so that's unusual. A 17-year-old, there should be some plan for college. I don't know who your judge is. Maybe you guys, went to trial and it was contentious and the judge said, I'm not willing to go that far. It's unusual. There should be a plan. But a 17-year-old should also know in some ways what they want to do. You should, as a parent, what kind of student they are. If the 17-year-old is a great student, they're probably going to say, hey, mom or dad, I want to do this. I want to go to a 4-year university. I want to go away from home, or whatever the case may be. So I don't know. To answer your question, I don't know why the judge didn't put it in. It should be in for any kid that's at least a sophomore in high school, or there should be some sort of framework. It's unfortunate that wasn't in there. The best thing you can do is, number one, talk to your child, and knowing your child. Maybe your child's a C student and they need to start at community college. That's fine. Then start them at community college. But you do need to talk to your spouse about it. And depending on your relationship with them, that may be difficult. If you find that you can't talk to your spouse about it, you need to write a letter, put something in writing that says, hey, I want to talk about college. There is a cap on the statute that neither parent the parents combined will not be obligated to pay more than the cost of the in-state tuition at University of Illinois at Urbana-Champaign. So maybe husband's wealthy and mom's a homemaker, and maybe husband's going to be paying 90% of it and mom's going to be paying 10%, but overall that's capped at the U of I rate. If you guys agree that your kid's going to go to Harvard or some fancy private school and you're going to pay for it, that's fine, but the court's never going to make you do that. U of I right now is about $36,000 to $38,000 all in per year per child. That includes room and board. So in short, my biggest thing that I want you to take away from this is, do not wait until your child's already in school, because if your ex-spouse is going to be difficult, you need to file a motion to preserve that the claim is going to go back to the date of the filing. File a motion and send it to them. So you put them on notice that you're asking for contribution, because if you wait and you're after freshman year of college and you're 40 grand in the hole, and you file your motion, you are not guaranteed to get any of that 40 grand back if you paid it out of pocket. So you got to start the process before the child starts school. The best way is to have that conversation, and maybe it's just a simple text like, hey, there's a cap based on the U of I rate. I'm not going to pay for more than the cap. We need to talk about where our kid's going to go to school. We need to submit a FAFSA. We need to apply for student loans. Your child can have an obligation. You can apply for the minimum, federal subsidized loans. And I think there's like an amount for the first year, an amount for the second year, amount for the third year, fourth year, and it gradually increases, and every child is entitled to that loan. So maybe you say, hey, look, you're going to get the federal loans to your child, and then your father and I will help you with the rest of it. But you do need to talk to the other parents.
All right, thanks. Okay, we've got just a couple more. I think we can get through a few of these. Can financial support be audited every year with changes in pay? Do I have to disclose every promotion I get to my ex-spouse from here on out? We are going with no child support / no maintenance, splitting the kids 50-50. But if that changes and I get the kids more, how is child support recalculated?
Okay, so child support is calculated based on an income shares model. So we have a software program where we plug in each of your incomes and the amount of kids you have, and it spits out a number. The only change is if one parent has more than 60% of the time, you get one number. If that drops to one parent having, over 40% and the other having under 60%, so closing in on a almost 50-50, the threshold is 40%. The above 40% parent pays less in child support. So there's a step down once you hit that threshold. Again, the software program spits it out, and I can run it for you. I can't tell you offhand. And then, so the first question was, do I have to disclose every promotion? So it depends on what your agreement says. We often do write in our agreements that there is an annual exchange of tax returns every year. That is usually with higher income people. For example, let's say one party is in sales and their income fluctuates, or they maybe get this big bonus that's not guaranteed, it's performance dependent. That would be a reason to exchange tax returns every year. Obviously, that some people don't like that. So it really depends on what your agreement is. But there is a good chance that if your income fluctuates, that a judge could order you to exchange tax returns every year. It's all negotiable. So I would need to know more about your situation. It sounds like you don't want to, and that's completely understandable. Then you should set out a framework for support that is very self-executing, that doesn't require you to continue to, let the other side know. Generally speaking, you don't have to notify of every promotion. The most that would happen is you just exchange tax returns every year, and that's how they would find out. At most. Sometimes you don't have to exchange tax returns. We can talk separately about that.
Okay, fantastic. All right, last question that we have here. Is it possible to not lose half of a business that you started while married to your spouse in a divorce? What if I have a controlling alcoholic husband?
It is possible to not lose half of a business. If you started it during the divorce, generally speaking, it's a marital business. Whereas if you started it before the divorce, it's a non-marital business, which you'd be awarded. So we're assuming you started it during the divorce. It's your business. You need
Started
to
the business while they were married.
Yeah, that's right. While they were married.
Yeah.
And you can be awarded the business, but then it becomes a question of, does it have value, and do you need to buy out half of the value? Valuing businesses is complicated. If you can agree on the value, I'll give you a general high level look at this. Let's say you're the only person that owns the business, and it's all about your services. And if you leave the business just collapses, then it probably has no value because it's just you. If you are one of many partners or shareholders in a corporation, Like, let's say you are a doctor in a big medical practice, there's probably some value, which means you have to figure out what the value is and buy them out. If you're a sole proprietor, there probably isn't much value separate and apart from you. So maybe the value for purposes of the divorce is 0 and you're just assigned all of it and you're assigned all the debt associated with it, if any. So yes, it's possible. To answer your question, we would need to talk more details.
Okay, you already kind of talked about the most affordable way to get divorced, but there's just one more thing here. Someone asked, how soon after a divorce can I get remarried?
If your judge stamps your decree now at 9:41 a.m., you can get married at 9:42 a.m. As soon as the judgment is stamped, you can get remarried.
Okay, so there's no waiting period.
No.
Is
No
that
waiting.
countrywide or Illinois specific?
As far as I know, it's countrywide, but I only practice in Illinois, so I couldn't say for sure.
Yeah. Okay, well, thank you so much. We touched on at least a little bit of every question that I got here. If you submitted a question that we didn't get to, Lisa, tell us a little bit about how people can get in touch with you, and if they want to talk more with you, tell us just a little bit about what a free consult would entail.
Yep. So normally I do charge for consults and they last an hour. So what I'm offering is a 30-minute free consult. We can do it via Zoom, or if you're local or would like to meet me downtown, we could do it in person. First step would be, I need your name and your partner, your soon to be ex-spouse's name, or the father of your children, so I can run a conflicts check. In the off chance that they've already consulted with somebody at my firm, then I would not be able to consult with you. Chances are probably very slim. Once we clear the conflicts check, then I would just have one of my paralegals reach out to you to schedule a convenient time. And, a lot of people are doing it via Zoom. If you wanted to send me an email in advance with some specifics, I'd review it in advance so I could be prepared to answer your questions. And like I said, I do go downtown sometimes, and I can meet you downtown as well for 30 minutes.
Just that raised a question. I've seen on Facebook a lot the suggestion that you should get a bunch of consults with lawyers before you hire lawyers, so that you can be on a bunch of conflict lists, so that your ex-spouse can't hire a lawyer. Is this good advice or bad advice?
It's kind of a low move. I mean, everyone has their own motives. People do it. I would say just consult with a couple of lawyers so you can get a couple different perspectives. Don't try to conflict out everybody. I mean, some people do it. I don't know. Your ex-spouse may have had multiple affairs and given you hell through your marriage. Then maybe that's what you're going to do. But is it good advice? No, I wouldn't recommend it.
All right, guys, you heard it from Lisa. Okay, thank you so much for coming on, Lisa. I really hope that if you're listening and you need some legal advice, that you take advantage of Lisa's free consult. If not with Lisa, with someone. You have options, you have rights. There are people who can help you no matter how dire your situation seems. I hope that you have kind of gotten the sense that there are answers to your questions, there are things you can do, and there's always sort of like the next chapter of your life. So keep that in mind. I'm cheering you on. Please leave your comments. We will copy and paste Lisa's contact information here as well, so that you can get in touch with her. And thanks so much for joining us today, Lisa. I appreciate your time, and hope all of you guys have a good rest of your day.
Thank you, Liz.